Hello friends, in the series on the income tax cases, today we will discuss once again a very important issue on section 153D approval which is required in the cases of assessment orders to be passed in case of search. In the present case, the issue before Delhi ITAT B bunch was that if an approval is given under section 153D for multiple years through a single letter on the same day in which it was sought, and it was completely in violation of the Direct Tax Manual 2003 February, so whether the assessments should be quashed solely on this ground that the approval is not as per the Direct Tax Manual. This issue has been taken up by Delhi ITAT B bench in the case of Dheeraj Chaudhary versus Assistant Commissioner of Income Tax, and this case is reported in 127 ITR Tribunal at page number 482, and the date of the judgment is 12th September 2025. In the present case, the approval for 7 years was sought by the assessing officer, and on the same day the approval through a single letter for 7 assessment year was given by the approving authority without having any remarks for the additions made by the assessing officer, without reviewing any searched material, without reviewing any assessment records, and without reviewing any submissions of the assessee. When the assessee challenged this assessment on the ground of mechanical approval, the tribunal said that there is a Direct Tax Manual of 2003 February in which there is a complete procedure of giving the approval has been mentioned. According to that procedure, the assessing officer has to forward the draft assessment order along with the seized material, along with the assessment records, along with the submissions of the assessee 1 month before to the approving authority, and it should be duly docketed in the order sheet when the proposal is sought, and again at the time when the proposal is granted by the approving authority, meaning thereby that both the events should be docketed in the order sheet. The tribunal further said that due opportunity should be given to the assessee before granting the approval by the approving authority to the assessee. The tribunal said that when the section 143 subsection 3 assessments are made, the assessing officer can call for any information, and if the assessing officer does not follow any decisions of any tribunal or high courts or the Supreme Court, then the assessee has a right to approach to these courts. But those decisions do not mean that, or the courts cannot guide the assessing officer to make the assessment in a particular way. Similarly, even the additional commissioner or the joint commissioner, who is the approving authority, has to give the approval when the draft assessment orders are prepared, but they cannot guide the assessing officer in preparing the draft assessment order. This thing was said by the tribunal because the revenue was harping on the submissions that the assessing officer and the joint commissioner were in due discussion regarding the draft assessment order. So for this, the tribunal said that the process of approval starts only when the draft assessment orders are prepared. The tribunal said that in the present case, since the approval has been given on the same day when the approval was sought, and the tribunal said that 153D mandates that the approval for each year should be given separately, since there is no review by the approving authority while giving the approval of the seized material, of the submissions of the assessee and other material which was necessary for the assessment proceedings. So in that case, it can be safely said that the approval is mechanical and the assessment should be quashed on that ground. Friends, this case is very important as far as the approval under section 153D is concerned, according to the tribunal, this is a inbuilt protection available to the assessee regarding the high-handed additions made by the assessing officer. At the end of this video, once again I am repeating the name of the case. The name of the case is Dheeraj Chaudhary versus Assistant Commissioner of Income Tax, and this case is reported in 127 ITR Tribunal at page number 482, and the date of the judgment is 12th September 2025. Thank you, friends.